Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, we're going to geek out a little bit again today. We're going to talk about the Bruen opinion. Why does it matter? What's the most important component? What does it all mean to you? You know, in our last video, when we talked about the common use test, we talked about the brilliance of Justice Scalia, and really in the same way we're going to have to do the same thing on Justice Thomas. Sometimes you think that many of these judges are actually almost clairvoyant in nature. They could almost see the trouble that was brewing, and we see that exact trouble when we take a look at the types of legislation that's being proposed in states like right here in Washington State, Oregon, California, New York, New Jersey, Maryland, and some of the other states that are proposing some of the most outlandish and violative gun control pieces of legislation we've seen anywhere. So today we're going to have to spend a few very important minutes kind of help you guys better understand the beauty of Bruen and why it matters now more than ever. Okay, so the issue we're talking about today is New York Pistol and Rifle Association v. Bruen, predominantly the holdings and the opinion of the chief author of that, Justice Clarence Thomas. Now, there have been a lot of people who've tried to explain Bruen, and they've done a very good job out here in the YouTuberverse. A lot of them have been kind of long-winded, a lot of them have been kind of boring, some of them have been not completely correct. What I'm going to try to do is give it to you in very short, digestible pieces so that you can understand the true importance of this opinion and how it matters to us greatly right now in a time where we have legislature after legislature after legislature around the country basically thumbing their nose at the United States Supreme Court and writing laws that are not only in violation of the pretty clear language of the Second Amendment, but also violative of the direct holdings of cases such as the Bruen opinion that we're going to discuss today. Now, following up on the Heller opinion, what the great debate had always been in the Second Amendment community is when we are taking a look at the constitutionality of gun control regulations, what actually is the test? Now, even though Justice Scalia had made it quite clear that the test should basically be, hey, listen, does the text of the Second Amendment cover the type of activity that's being restricted by the law? If the answer is yes, then it's per se unconstitutional unless government can come up with a historical analog to show, no, we actually have a tradition of restricting guns in that fashion. Now, what happened at the lower court levels is they were engaging in that first part of the test, but then they were adding their own part 2A, if you would, which would basically be, well, let's do a balancing test now. We're going to weigh the societal interest, all the interest of society as a whole, and compare that to the little infringement on this poor individual and figure out which one reigns supreme. And of course, that balancing test allows courts that have a political agenda to put their thumb on the scale one way or the other and allow for legislation either to fail or succeed. Justice Thomas in the Bruen decision, which basically struck down New York's ridiculous concealed carry laws that basically made it impossible to conceal carry. But in further defining what the test is moving forward for how we're going to analyze gun control legislation, Justice Thomas made it very clear that it is not a two-part test, it is a one-part test. And that one-part test is pretty simple. Is the activity protected by the text of the Second Amendment? If so, it is per se unconstitutional. The only way that we can find a justification for that regulation is if the proponent of that regulation can offer us a historical analog that shows that our country has a tradition going back in time, not back 10 years, not back 20 years. The debate we're going to have is how far back do we go, but going way back to the near ratification of the Constitution. If there is not a historical analog, then that is not the Constitution as we ratified it at the time of its inception. Now, the great debate is this. How far back do we have to go? Because you can understand that if we have to go all the way back to 1791, the date in which the Constitution was ratified, the year in which the Second Amendment was ratified, we know that there are very few, if any, restrictions on magazines, semi-automatic rifles, certain types of ammunition, or any of the other crazy gun control measures which currently stand in place around the United States. Now, if, however, as some have suggested, that we actually have to look at 1868 as the date. Why 1868? Well, 1868 is the year that we ratified the 14th Amendment. The 14th Amendment basically took all of the Bill of Rights and subjected the states to them as well. Basically, that states cannot deprive you of constitutional rights as well. Now, this is in a response to the abolishment of slavery and the Civil War. So many who continue to argue that Bruen really doesn't have the meaning that those advancing the Second Amendment believe it does will say, no, the correct time to go back and look at when types of gun control legislation we have is actually 1868. So the question is it 1791 that we have to go back to, or is it 1868? But actually, the better question should be, does any of that even matter? You see, because here's the thing. If we are taking a look at both the common use test, which is we are taking a look at the types of firearms that are in common use in existence today, and we are also taking a look at Second Amendment legislation under the very clear one-step analysis of Bruen, that if there needs to be a historical analog, some kind of a rich historical tradition of the United States allowing gun control measures of a similar nature to exist, it really doesn't matter whether we look at 1791, because there was no magazine restrictions, there was no assault weapon restrictions, there was no such thing as an assault weapon. There was no such thing as semi-automatic rifles. There was no such thing as semi-automatic rifle bans. There was literally no prohibition against any firearm so long as the firearm was not deemed both dangerous and unusual. When we're talking about magazines and semi-automatic rifles, there is nothing unusual about either one of them. However, if we go back to 1868, even if we acquiesce, if we concede that point to the gun-grabbing left, here's the problem. There is at that point a pretty rich tradition of American gun control measures. In fact, we could go back to 1640 in Virginia and take a look at gun control piece of legislation after piece of legislation after piece of legislation through colonial times, through the early adoption of the Declaration of Independence, all the way up to post-Civil War. The only problem for them is that every single one of those pieces of gun control legislation is rooted in one thing and one thing only, and that is prohibiting a person from possessing a gun based upon the color of their skin. Do any of us want to guess what color is singled out in every single one of those pieces of legislation? So the beauty of Bruen is this, is that if government is going to try to justify a gun control regulation by placing upon it or likening to it a historical analog, they don't get to go back to the 1980s. They don't get to go back to the 1970s. They don't even get to go back to 1934, the first time we adopted any form of federal gun control legislation. No, at the best case scenario, they're going all the way back to 1868, where every piece of gun control legislation is rooted in obvious racism, or they're going to have to go back to 1791, in which we had just finished ridding ourselves of a tyrannical government, and I can assure you no citizen was willing at that point to limit their ability to defend themselves and their family. And that, my friends, is the beauty of the Bruen holding. Justice Thomas realized that if we allow modern regulations to redefine the very words of an amendment to our Constitution that was ratified in 1791, then we are no longer living under the document that the original founders ratified for us to live under. This is the importance of Bruen, and this is why assault weapon bans, semi-automatic rifle bans, magazine bans are all living on borrowed time. Listen, you may have more questions about this or anything else related to your Second Amendment rights, and if you do, you know the drill. You can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.